Judgment in the matter of Law Debenture Trust Corporation against Ukraine.
Many of the cases which come before this court concern disputes between foreign individuals, foreign companies, or foreign governments. Very often, their dispute has no connection to the United Kingdom, but they have chosen to have their relationship governed by English law and have chosen the English courts as the place where any dispute should be determined. This appeal is an example. It concerns a commercial dispute between Ukraine and a trust corporation acting on behalf of Russia. The dispute concerns a loan of $3 billion made by Russia to Ukraine in 2013, which was repayable in 2015. Russia paid the $3 billion to Ukraine, but Ukraine has not repaid the debt. In these proceedings, the Trust Corporation is suing Ukraine for repayment. As the loan documentation provides that the agreement is governed by English law and that any dispute can only be decided by the English courts, the case has come before this court. It's our duty to decide it in accordance with English law, applying the law with complete impartiality. The appeal was heard before Russia's invasion of Ukraine last year, and neither party has argued that the invasion is of any relevance to our decision. The Trust Corporation's case is that the $3 billion is due to be repaid under the terms of the loan agreement. Ukraine's defense raises four issues. First, it said that Ukraine lacked the capacity to enter into the loan transaction under Ukrainian law. Secondly, it said that Ukraine's Minister of Finance lacked authority to enter into the transaction. Thirdly, it said that Ukraine is entitled to treat the agreement as a nullity because it was entered into under duress. Fourthly, it said that Ukraine is entitled to rely on the international law doctrine of countermeasures to decline to repay the debt. The Trust Corporation has applied for summary judgment, a procedure which enables the court to decide a claim without a trial where the defense has no real prospect of success. The trial judge granted the application and ordered Ukraine to pay the sums due. On appeal, the Court of Appeal upheld the trial judge's conclusions on three of the issues: capacity, authority, and countermeasures, but held that the claim should proceed to trial on the issue of duress. The Trust Corporation then appealed that decision to this court, and Ukraine cross-appealed against the Court of Appeal's decision on the issues of capacity, authority, and countermeasures. The Supreme Court unanimously holds that the Trust Corporation is not entitled to summary judgment, which means that Ukraine will be permitted to defend the claim at a trial before the High Court. The majority of the court hold that Ukraine should be permitted to defend the claim on the ground of duress, but only to the extent that it is based on Russia's alleged threats to the safety of Ukrainian people or property. Ukraine's defences on the issues of capacity, authority, and countermeasures should be struck out. Lord Carnwath agrees with the majority on the issues of capacity and authority, but would have allowed the defence of duress to proceed to trial on a broader basis. He also considers that the countermeasures defence should be permitted to proceed. Explaining the reasons for the majority's decision in more detail, on the first issue, whether Ukraine had the capacity to enter into the agreement, the court holds that as a sovereign state recognised by the UK government, Ukraine is a legal person with full capacity in English law. The court rejects Ukraine's submission that its ability to enter into contracts was limited by Ukrainian law, since the capacity of a sovereign state under English law derives from the state's recognition by the UK government and not from the state's internal law. On the second issue, whether the agreement was entered into without authority, the court holds that the events leading up to the agreement, which involved the President of Ukraine, the Cabinet, and the Minister of Finance, demonstrated a consistent approach to the borrowing. The Ukrainian Cabinet passed a resolution authorizing the Minister of Finance to proceed with the transaction. If a state represents that a person has authority to act on its behalf, it will be bound by the acts of that person as regards anyone dealing with him in reliance on that representation. On the third issue, duress, the majority of the court holds that a party is not bound by a contract where its consent to the contract is induced by threats or pressure which are illegitimate under English law. In this case, the duress is said to have arisen from restrictions imposed or threatened by Russia on its trade with Ukraine, and from threats to Ukraine's territorial integrity and independence. So far as the allegations concern trade restrictions, it has to be borne in mind that restrictions on trade, such as sanctions, embargoes, and protectionism, are normal aspects of statecraft regularly exercised by this country and other countries. They cannot be regarded as inherently illegitimate under English law. Accordingly, the economic pressure alleged by Ukraine cannot in itself establish a defense of duress. On the other hand, the alleged threats to use force against Ukraine may constitute duress. Threats of violence to persons and of the destruction of property are well-established examples of illegitimate pressure under English law. Accordingly, the success of Ukraine's defense turns on whether it can establish that Russia threatened the use of force and that those threats were a reason for Ukraine's decision to enter into the agreement. That question can only be determined after trial. If the economic pressure is found to have accentuated the impact of the threats of force, that will strengthen Ukraine's case. On the fourth issue, whether Ukraine can maintain that non-payment of the debt is a lawful countermeasure, the doctrine of countermeasures is a principle of international law. The majority of the court hold that it cannot be applied by the English courts, since English law does not recognise such a defence. The court will now adjourn.